As I mentioned, we have a very outstanding contributor to the program who goes by the name of Chris Wiseman over on Locals. And he posted this earlier today. He said, this would be hilarious if it weren't so gruesome. Man douses himself in gasoline, threatens to kill himself. This was posted by Akchara over on Twitter. And he was referencing us over here to this case from the U.S. Court of the Fifth Circuit. It's a qualified immunity case. Cop number 1, he said, quote, if we tase him, he's going to light on fire. Cops 2 and 3 say, well, okay, tase him. Man lights on fire, burns alive. House also burns down. Fifth Circuit says qualified immunity. He was threatening arson. Therefore, you're allowed to torch him. You're allowed to torch down the rest of the property. That sounds nice, right? Sounds kind of on point. So let's get into first of all, thank you, Chris, for alerting us to that. Let's go through the opinion. This came out about a week ago, and I think it's important. It's an interesting one to read. And it says here, the United States Court of Appeals for the Fifth Circuit filed February 8th. It's Selena Marie Ramirez. She's the independent administrator on behalf of the estate. So the person who died is Gabriel Eduardo Olivas, and got different heirs at laws. And so what is happening here is Selena Marie Ramirez is suing the officers, okay, for killing him. Let's go through the facts. And this is before Jolly, Stewart, and Oldham, who are all circuit judges. Pure curiam, so it's sort of the opinion of the court. This case arises out of the tragic death of Gabriel Olivas. While responding to a 911 call that Olivas was threatening to kill himself and burn down the family's house, we have officers Guadarrama and Jefferson. They discharged their tasers at Olivas, striking him in the chest. Olivas had doused himself in gasoline, which ignited when the prongs of the taser came into contact. He was engulfed in flames. The house was burned down. He died of his injuries several days later. His widow and 2 children were subsequently brought suit. They said that they violated his Fourth Amendment rights when they tased him. They asserted that the officer said, nope, we have qualified immunity, and they moved for dismissal. But the district court, the lower level court, remember, this is on the Fifth Circuit Court of Appeals, they denied the motion to dismiss the case. They said, no, we need more factual development. The officers then filed this appeal. We reversed the denial of qualified immunity and remand to district court with instructions to dismiss based on the claim against the 2 officers. With this background, we now go on to explain further. So, quick recap. We have Gabriel, who is at his home. Apparently, he's covered in gasoline, threatening to burn himself and kill himself and burn the house down. Cops show up, some sort of altercation. They tase him. He ignites because he just got jolted with volts of electricity. Something happens. He goes back to the house. House burns down. He dies a couple days later. Burns all over his body. Family says, all right, well, that's it. So cops shouldn't have done that. You knew better. Shouldn't have happened. And they sue. At a lower level district court, the lower level court said, no, this needs to go forward. We needed to develop the facts more. Cops said, no, this should be dismissed because we have qualified immunity. We are immune from lawsuit. We're not liable for that damage. We're not responsible for what we just caused there because they have certain levels of immunity. And so this court goes on. It says, upon entering, Officer Guadarrama detected an odor of gasoline. A woman directed the officers to a corner of the bedroom on the east side of the house. They found Gabriel there, leaning against the wall and holding a red gas can. After turning his flashlight on, Officer Elliott allegedly shouted to Sergeant Jefferson and Officer Guadarrama, quote, if we tase him, he is going to light on fire. Okay, so they knew that this was a real thing. They knew that this could lead to this outcome. This was foreseeable. It was predicted. It was discussed. Elliott then discharged OC spray in Olivas' face, temporarily blinding him. It was at about this point, whether before or after being sprayed is not entirely clear from the record, that Olivas doused himself in gasoline. Guadarrama and Elliott, at least, maybe Jefferson as well, noticed that Olivas was holding some object that appeared as though it might be a lighter. Guadarrama, followed in short succession by Jefferson, fired his taser at the gasoline-soaked man, causing him to burst into flames. We've got Colonel Ray, Officer Scott arrive at the scene at about this time. When they entered the house, they found him engulfed in flames. The fire spread from Olivas to the walls of the bedroom. The house eventually burned to the ground. The officers at the scene were able to evacuate the family members who had remained in the house, but he was so badly burned, he later died from his injuries. Olivas' wife and son subsequently brought suit. saying that the officers violated his Fourth Amendment rights when they tased him. Each of the officers said, no, we're immune. We have qualified immunity as a defense, and they moved for a dismissal according to Rule 12b-6, failure to state a claim. The district court denied their motions, finding that more factual development was needed. Then we get into some qualified immunity analysis, and I want to spend a little time on this. They say here that qualified immunity has two components. Number one, whether a plaintiff, so the person who's filing the lawsuit, whether they're showing or alleging that the violation was a violation of federal constitutional or a statutory right. So they need to get very clear on what is being violated. And then number two, whether the right in question was clearly established at the time of the alleged violation. All right. And I want to just show you briefly sort of what that might look like. So we have a little bit of new technology here on the show. Let's see if I can make this work. So we're talking about qualified immunity. And what I want to do is just draw a line right here. That is the qualified immunity line. So we're going to say this is the QI line. That is qualified immunity. Anything that's above the line is okay. And anything that is below the line is bad. That's not okay. The court is going to say that's not good. We're not going to allow that to happen. And as we're going to go through here, you're going to see that the courts are sort of defining the different categories. So it says whether the right in question was clearly established. And so when we're talking about this in the context of a lot of the crimes that we've spoken about here, right, you can make the argument that, well, let's take some examples of cases that we've covered here. We just heard from the questioner at Biden's town hall that the DA gravely dismissed any charges or refused to file charges against the officer who shot Jacob Blake in the back 7 times. Okay, so was that officer immune from criminal charges? Yes. So we can put Jacob Blake up here above the line, right? We'll put Jacob Blake up here. He's above the qualified immunity line. There was nothing wrong with what happened there. Now, George Floyd, we still don't know, right? George Floyd is still sort of pending, but we're probably going to guess that that goes down here. George Floyd, the police officers did not have qualified immunity to lean on his neck for 8 minutes and 46 seconds. Okay, same things. Other cases are still pending. Ahmaud Arbery, remember that one where there was that young man who was running through the streets. Other police or other people who used to be police officers, they came, they ended up shooting him, and now they're being charged with crimes. So Ahmaud Arbery would certainly be below the line because the qualified immunity standard, whether there was a right that was clearly established that the police didn't violate, that is below the line, right? So Ahmaud Arbery would be below the line. We got Rayshard Brooks, probably below the line. They're not going to get qualified immunity for that. He was running away and he got shot in the back. Brianna Taylor, though, right? Brianna Taylor, what happened there? All of those cops, they were basically immune. Now they didn't get away on the qualified immunity statute because they just were not indicted. There was no case actually brought against them. But they are above that line. So we got the Brianna Taylor case here, which is also sort of it's okay. It's acceptable. And so what the court is going to do is they're going to try to distinguish this. And so sometimes this line will actually move. They'll say, all right, well, we're going to protect more of this content. We're going to raise this line up just a little bit. And then sometimes in other courts, they'll move it down for different conduct. And so we're always trying to figure out where this line is because it is sort of moving. It's changing around. And we had talked about specifically cases from Amy Coney Barrett, our newest Supreme Court justice, and she was sort of making that line smaller, making it less applicable to some additional conduct. In other words, the police had not defined that was a clearly established right at the moment, and therefore they're not going to be held accountable, or they are going to be held accountable because qualified immunity doesn't apply. So I don't know if that makes any sense, but that's sort of how I was thinking about it as I was reading this opinion. It says here, since Pearson, a reviewing court may tackle these questions in whatever order it deems to be most expeditious. The second question, addressing whether a right is clearly established encompasses another question discussed separately in the court's opinion. In order for a right to be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. Okay, so let's think about what we might be talking about here. Did he have a right to not get shot with a taser when he was covered in gasoline? All right. The reasonableness of the official's conduct and the degree to which the particular right in question was clearly established are thus merged into one issue for the purposes of qualified immunity analysis. The opinion goes on. We view the disputed facts in the light most favorable to the plaintiffs. Guadarrama, Jefferson Elliott arrived at the house in response to a 911 call, having been told that Gabriel was threatening to kill himself and burn down the house. They found him in a bedroom that smelled of gasoline. He was holding a gas can. Officer Elliott shouted, quote, "If we tase him, he's going to light on fire." Elliott then discharged OC spray, temporarily blinding him. Gabriel began to shout nonsense and yell that he was going to burn the place to the ground. He poured gasoline over himself. At some point before either taser was discharged, Officer Guadarrama and Elliott noticed that in his hand he appeared to have a lighter. They fired the taser, striking him in the chest. He burst into flames. Jefferson then fired his taser, which also struck Olivas in the chest. So they didn't want him to light himself on fire, so they lit him on fire. Am I reading that right? All right. Having set forth this factual background, yeah, he had a lighter in his hand. It wasn't a gun, right? It wasn't a knife. It was a lighter. Appeared to be a lighter. They didn't want him to light himself on fire, so they lit him on fire themselves. Having set forth this factual background, we now consider the reasonableness of the force that was employed. Graham sets forth specific factors to be considered in the reasonableness inquiry: the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, whether he is actively resisting or attempting to evade arrest by flight. Here, the severity of the threatened crime, quote, felony arson, was considerable. What a joke. What an absolute joke. He posed a substantial and imminent risk of death and serious bodily injury to himself and everyone in the house. Well, they had multiple officers there. They could have escorted them out of the house immediately. That would have negated that. He was covered in gasoline. He'd been threatening to kill himself and burn down the house. He appeared to be holding a lighter. At that point, there were at least 6 other people in the house, all of whom were in danger, which is a crock, right? They could have gotten them all out. Other officers were arriving. This didn't happen in 10 seconds. The final Graham factor of the reasonableness inquiry is whether Olivas was attempting to flee or evade arrest, which is not of relevance here. No, of course not. This is from the Fifth Circuit Court. These are really renowned judges. Although the employment of tasers led to a tragic outcome, we cannot suggest exactly what alternative course the defendant officers should have followed that would have led to an outcome free of potential tragedy. Well, let's see if we can think of one. Well, they could have just sat there, right? They could have just sat there and let him light himself on fire. If he wanted to light himself on fire, they could have just said, all right, well, we're just going to stand here for an hour and do it then. Do it. Okay, could have called a psychologist in there, a community response team, a hostage negotiator, anybody to have a conversation. Could have called the neighbor, could have brought the wife in, right? Could have just had a simple conversation with the guy. It sounds like he was just sort of in the corner, covered in gasoline with a lighter. If he wanted to light himself on fire, yeah, there's going to be no liability for the police there, but they could have just stood there. They didn't have to do something. This is one of the biggest problems that I hear anytime that people want to come and defend the cops on this channel or anywhere. Well, they had to do something, right? The 9-year-old girl who got pepper sprayed in the face, well, she wasn't cooperating and that's her fault. And we have to do something. We can't just sit here and deal with this. We got other places to go. Okay. Or you can just wait. You can just hang out for an hour, let her calm down. She's having a panic attack meltdown because she thinks that you just shot her father or whatever the story was there, or the mom stabbed the father or something like that. You don't have to just diffuse every scene immediately with the use of force. You can just stand there. If he wants to light himself on fire and burn the house down, that's fine. Get the other people out and manage the situation. Am I off on that? The Fifth Circuit Court couldn't figure that out. The police have to take action in a situation like this. They can't just stand there. We emphasize that the reasonableness of a government's official use of force must be judged from the perspective of a reasonable officer on the scene, not with the benefit of 20/20 hindsight. Well, yeah, a reasonable official on the scene said, if we shoot him, he's going to light on fire. So we know that was kind of a known fact. The fact that Olivas appeared to have the capability of setting himself on fire in an instant, and indeed was threatening to do so, meant the officers had no apparent options to avoid calamity. If reviewing the facts in hindsight is still not apparent what might have been done differently to achieve a better outcome under these circumstances, and certainly we, who are separated from the moment by more than 3 years, cannot conclude that Guadarrama or Jefferson, in the exigencies of the moment, acted unreasonably. Okay. Given that Guadarrama fired first, the most readily apparent justification for the use of his taser was to prevent Olivas from lighting himself on fire. So they lit him on fire. They helped him with that. They wanted to stop him from lighting himself on fire, so they lit him on fire. Jefferson fired second, while at one point he claimed to have fired instinctively. Plaintiff alleges that he did so intentionally. Accepting plaintiff's allegations is true. Jefferson still has good reason to try to immobilize Olivas to prevent him from spreading fire around the house. But they did that. The police did that. They lit him on fire, and then it spread around the house. So what did that work? Moreover, at that point, there was no risk that using a taser might ignite a fire since Olivas was already engulfed in flames. So that was after the second person shot, right? So the second guy is, he definitely doesn't have any fault. And I actually agree with that, right? The first person who fired the taser, they ignited him. Somebody else warned him, hey, if we shoot him, he's gonna ignite, and they shot him anyways. The second person was just after the fact. All right, well, he's already torched, so why don't I just shoot him as well? Maybe that'll help. Accepting the pleaded facts is true and construing them in a light most favorable to plaintiffs, neither officer's conduct was unreasonable, nor was the force they employed clearly excessive. We thus find that plaintiff's factual allegations do not make out a violation of his Fourth Amendment rights. The plaintiffs have asserted that the officers violated the Fourth Amendment rights of their deceased husband, father, by using excessive and unreasonable force. Officers have invoked qualified immunity from the lawsuit, arguing there was no constitutional violation because their use of force was reasonable under the circumstances. We have found that given the horrendous scene of the officers were facing involving the immediate potential for destruction of lives and property that they caused, that it was not unreasonable. We hold the officers did not violate the Fourth Amendment. They are thus entitled to qualified immunity. For the reasons given, we will reverse the order, denying qualified immunity, and send it back down to dismiss all the claims against the officers. All right, so when we go back to our little chart over here, we can just say you also get qualified immunity for lighting people on fire for the police. So you get qualified immunity for that. So you're good. So cops, now you know, just light up whoever you want. You're immune from that. Well done, Fifth Circuit.